solicitor, in his comments to you, said a bunch of stuff, and some of it I agree with, some of it I don't. I'd like to remind you at the outset that a moment ago, in the midst of his remarks, what he said was, and I wrote it down, they may have thought that the air conditioner was on. That's what he said. I will tell you right now, when you have heard the judge explain the law in this case, and you apply it to the facts that you've heard here, that sentence alone means the murder goes out the window. We'll talk about murder in a minute, but please, if you think nothing else about that opening remark, remember that the solicitor has conceded to you that Mr. King may well have thought that the air conditioner was on in that car. Now, ladies and gentlemen, I'm here on behalf of Mr. King. My remarks to you are addressed solely as relates to Mr. King. Ms. Pangalangan has a really good attorney, smart guy. He's going to address you soon as relates to her. So again, understand, I'm not talking about the two of them. I'm talking about Mr. King. Another thing that the solicitor pointed out in his opening remarks that I agree with was he said, well, this child was totally dependent upon Rita. And he said it over and over, and it's because it's true. This was a child who was always going to be dependent on her mother, and her mother was responsible for her mother had to care for her, her mother may well have tried to do the best she could or not. I'm not talking about her, but I'm talking about the child who was completely in her care. There's no evidence before you that Mr. King was this child's father, Mr. King had adopted this child, that Mr. King and Miss Rita were married, and he was some sort of step-parent. He was dating her mom. It doesn't create some sort of legal bond between them or create duties that he has to do. This child is in the care of her mom, and he's visiting with her mother on that particular day. Ladies and gentlemen, when y'all return to the jury, when the judge is charged you on the law and suggests or instructed that you commence or begin your deliberations, it may be that if y'all read Mr. King's indictments first, they can simply say, looking at the laws the judge gives it to you, Larry is not guilty of the crime. At least he's not guilty of any one of these crimes alleged in this indictment. Larry didn't kill anybody. He didn't commit a murder. He didn't cause grief bodily injury to anybody. And I'll talk about the conspiracy shortly. There's going to be no evidence to support that. It may be that at the outset you say, I understand why the state's outraged. This never should have happened the way that it did. But Mr. King didn't kill him. If that's the case, I don't know if we have a full person. But if that's the case, whoever the full person is on the jury, you're fully entitled to this right to not guilty. Set those indictments aside and move on with whatever other business y'all have. But in the event that one or more of you feel like his circumstantial situation merits further discussion in the jury room or deliberation, I need to talk to you about a few more things, okay? First of all, the judge is going to tell you soon that every person charged with a crime is presumed innocent of any wrongdoing. And I know somebody wrote a book and they made a movie called Presumed Innocent and stuff like that, but it's an absolutely critical term of art when used in court here today. And what it means is the defendant, although he chose to testify, has absolutely nothing to prove during the course of the prosecution or during the course of his defense. And you have a right to remain silent, and that right cannot be used against you if you choose to exercise it. It's because of the presumption of innocence. It doesn't mean we'll wait and see. Maybe, maybe not. Show me what you got. It means at the outset of the trial, even at this point, you look at that paper and you say, he's innocent. It's critical. And then you look at this table and you say, okay, Mr. Solicitor, your office brought the indictment, your office called the case, your office summoned or report summons here to try the case that you're scheduled. Prove to me that the defendant is guilty of the crimes in this indictment or in these indictments. to meet that burden. What it means is they have to prove every element, ingredient, element. They have to prove every element of the crimes that are alleged within the indictment. They have to prove them beyond a reasonable doubt. So this isn't civil court. I don't know if you've done that. Sometimes you see the statue, Lady Justice, when she's holding the scales and it tips a little. In civil court, it's preponderance of the evidence. It tips one way or the other, that side of it. It's not that way here. Today it is proof beyond a reasonable doubt. In the state called a murder indictment against Mr. King, alleging that he had murdered a child. It means they make you a promise as jurors that they will dispel every reasonable doubt, every element, and prove beyond hesitation that Mr. King is a murderer and that he murdered that child. I've talked about beyond a reasonable doubt. This term of art also is Judge Honor is going to define it for you. But a reasonable doubt, and he will tell you. I know you all pay attention to the charges. He will tell you that a reasonable doubt is the kind of doubt that would cause a person to hesitate to act in the course of their own most important affairs. And in any criminal trial, if your juror has that kind of doubt as to the guilt of the defendant, you are required by the oath that you took earlier to return the verdict not guilty. So, if we put aside some of what I would call the clutter or distraction in this case, and just look at what is actually relevant and what should help you in your search for the truth or in your weighing of the evidence that's been presented before you, I would suggest to you that most of what you've seen is more or less clutter, okay? I mean, the state called Dr. Grundy, the state called an expert from Georgia. He was an expert in heat. And he came from Georgia to tell y'all something that every one of you already knows. If you park a car in the direct sunlight in eastern South Carolina in August, with no air conditioner and the engine not running, it's going to get too hot to live in that car. So the charts and his testimony and all this, it's filler. Because it doesn't give you a chance to look in Mr. King's heart, which is what you're going to have to do shortly. We conceded in our opening statement that this child was in a car, that it got too hot, and she died. I submit to you that this professor from Georgia doesn't really bring anything new to the table. You can pretty much set it aside because we know what happened. It got too hot in the car and the child died. The pathologist is the same. You already knew before the pathologist ever took the witness stand what had happened with this child. You had heard us concede that this is what happened. You had seen the videotape and this is what happened. And you knew this child died from me. Really nothing is useful to you whatsoever. They called this police officer, Captain so-and-so, and I don't know why he's back up here today. But they called him to testify to this key fob. There's been a lot of talk back and forth. But really, what was necessary to hear from him was plain and simple. It came out yesterday. He said, if you unlock the car, or you lock the car, while the engine's running, the lights don't flash. Nobody ever locked or unlocked the car with a key fob that they retrieved from Rita's house. Because as you heard, the battery was dying. Once or twice they hit the key fob, the doors didn't unlock, the lights flickered, and then they didn't flicker anymore. So, fine. You lock it or you unlock it while the engine's running with the key fob, the lights don't flash. It never happened. It's irrelevant in this case. And as much as the solicitor wants to talk about methamphetamine in this case, because it's prejudicial and it's bad and people think terrible stuff, because it is a terrible drug. Much as he wants to talk about that, they're not charged with methamphetamine. And when the solicitor says the only reason that you know methamphetamine was involved in this case is because their expert came to testify to that, I submit to you that's not true. As a matter of fact, what their witness did to the toxicologist, while I submit she gave you nothing that would help you in deciding this case. She said methamphetamine goes to the cycle, you take it in, it peaks in your bloodstream, body processes, it goes out of your bloodstream. She says, yes, people get a tolerance to it, and I would submit to you that if anybody would have a tolerance to it based on all the evidence that you know, it's probabilistic. She also said that, yeah, Mr. King having 400, that was certainly a level to raise eyebrows or cause concern, but that she's seen it up to 2,000. This doesn't have anything to do with the charge of murder. We don't talk about that. But what she did do was give the defense, wrapped up in a nice box with a fancy bow, a gift to Mr. King. Because she said on the witness stand, under some fairly stringent cross-examination by Mr. Phillips, yes, this stuff can take up to 3 days to get out of your body. She further confirmed to him, I can't say if this is from ingesting methamphetamine that day or the night before, or if it's from 3 days before. I simply can't say that. You know, as jurors, that there's a whole lot of people who would have sat at the defense table, and that would have been the story. I took it 3 days ago, and I get on the stand. Only the second time I ever used it. 3 days before that, 2 days before that. I was just tired. That was the only effect I was under. I was outnumbered this time. Mr. King got to the stand, and he rejected that. He took an oath to tell you the truth. And where it hurt him, potentially, or at least made the solicitor real happy as being spoken right in the down, he told him. No one else was going to tell you he was addicted to methamphetamine. No one else is going to tell you he was what's called a functional addict. That is, that he used methamphetamine throughout the day to allow him to function. He's never been without work, so like disputes. Had 5 jobs in his life, like disputes. He's always been functioning, going to work, supporting himself, meeting his needs. But just as they're on a functional alcoholic, he was a functional addict. No one else was going to tell you. The solicitor knows that, right? He's probably going to talk about it some more because he loves talking about methamphetamine. Why did he tell you that? Because he tells the truth. Good, bad, let the chips fall where they may, this is what happened. It's not that he didn't want you to know it's a solicitor. The only time he hesitated to answer was when they asked about me. And according to his own code, he said, I'll speak for myself. And he answered the question with no further promise. But the judge will soon tell you that it's up to you as jurors to judge the credibility of the witnesses as they come in here to testify. And credibility means the believability. And there's no magic formula for it, but the judge will tell you it's your own opinion based on your own experience, your own worldview. But when a person testifies, you can see that they testify consistently or inconsistently. They testify, they contradict themselves, or they support it by other facts and evidence or other evidence that's being presented. And I will submit to you that if Mr. King will come in and give the state this gift, knowing full well it sounds bad, but he's honest enough to give you that, you can certainly find he's honest enough to give you the rest. If he'll tell you the things that are bad for him and you believe him, you can probably believe him when he tells you the rest of it also. Now, the state has charged Mr. King with murder. I assume it's the worst crime there is. And murder is not hard to define. Murder is the killing of a human being with malice aforethought. First of all, as relates to Larry's case, the murder indictment fails me. Okay? Larry didn't kill anybody. If you recall, when you think back to the solicitor's opening argument, or opening statement, his opening statement, he says that he's going to show you the videotape where Mr. King rudely comes down with this child, the doors open, he throws the child in like so much baggage that he just wants to be rid of her, and he uses the term 2 or 3 more times. She was just baggage. I know y'all watch the tape. My boys can't help it. We watch y'all very well. I watch y'all all the time. I know everybody paid attention. Everybody was involved in this. So, on behalf of Mr. King, thank y'all for that. But you didn't see that. What you saw, it's in evidence. You see it again if you need to. Was Mr. King come out, as he described, appropriately, properly, gently, maybe lovingly, but it's certainly appropriate, gently, appropriately. Place the child in the back seat. Move the child to put her in the proper position and be comfortable. Step back. Rita stepped up, put the seatbelt on, did whatever she was doing. She did what she needed to do, and the child settled in. That's all there did in this case. That is the sum total of what he did. He relinquished this child into the arms of her mother. He stepped away. I got feelings hurt, heartbroken the way he described it. I'm out, and he tells her to go. You just go. Leave. I'll talk to you later. She doesn't leave, obviously. She goes back and forth. But at that point, the solicitor would need to prove to you, hold on, that when Larry King put her in that car, he did it with malice. First of all, he's got to prove that putting her in the car killed her, which of course is nonsense. It didn't. He made efforts to make sure she was safe and well done and properly positioned in there. And then he's got to show that when Larry did that, when he put that child in that car, he did it with malice. That he killed her, and he did it with malice. What does malice mean? I'm going to read it to you. Sorry, I'm going to read it. Malice is hate, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstance in which the law will confer an evil intent. That's what malice is. So before you can even consider whether or not Mr. King should be convicted of murder, you have to consider whether or not there's any evidence whatsoever to make you believe he put that child in that car with hatred, ill will, hostility, or the intention of doing a wrongful act. And that's nonsense. And y'all met Mr. King. Y'all met him. Y'all had a chance to judge his credibility, his believability, and to determine whether or not you think he's the man, based on everything that you heard and everything you saw, whether or not the state has proved beyond any reasonable doubt in your mind that when he put the child in the car, he did it with hate, ill will, and malice. And it's nonsense. Further, malice can mean a general malignant recklessness for the lives and safety of the others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. And all of that's real strong language, and there's a reason for that. It's because it needs to be. It's the worst crime that there is. And if Larry actually walked out and put the child in the car with the intention of the line, driving her safely away, and then he stepped away and said, y'all go, and he doesn't do anything else to this family, there's no indication whatsoever of malice, hatred, or ill will. And without the murder indictment falls on him. It falls for element one, killing someone, and it falls for malice, because he didn't kill anybody, and there's no indication he had any malicious, ill will, ill intent toward this child. That's what the state promised to prove. Ladies and gentlemen, in your jury room, excuse me, in your jury room, you will have the indictments, and there are 3 indictments Mr. King is called to answer to. Murder, and I've addressed that. Inflicting great bodily injury on a child, and the argument is very simple. And a conspiracy charge. When you have those indictments in your jury room, you were fully entitled to look at them, examine them, and see what you think about those documents. You may notice, if you look closely, that shortly after this child died, Mr. King was indicted for murder. Period. Stop. And then as time went on, and a trial went, and the rubber's going to meet the road, we're going to put it to the test. Somebody looked at that murder indictment and said, this ain't going to fly. It was 2.5, maybe 3 years later, coming in for the trial, they came up with new charges. And that's just different. Look at the dates. Look at the dates. They got all this fire in their heart, absolute confidence in this murder case, we've proven that, etc. Why are you coming around at the back end and trying to get a fallback position? You know why. It's because there's no evidence of malice whatsoever. There's no evidence that killed anyone. That indictment goes by the wayside. The arguments as to inflicting great bodily injury upon this child are the same. Mr. King placed the child in the car. At that point, she's not in his house, she's in the car. Mom can get in the car and drive away. Mom can get in the car and drive away 100 miles an hour. Mom can go to walk. She can do whatever she wants to do. She's not his child. He is not responsible for this child. He is not the one who needs to take care of this child. He steps away and says, y'all just go. She's off his plane, so to speak. He didn't hurt her. He didn't cause her to be hurt. As a matter of fact, as the solicitor conceives, he thought the engine was running, the air conditioning was going, and she was off his plane. He'd seen nothing in Rita's past background to cause him concern that she wasn't able to care for her child, or in some way she was going to allow the child to hurt, or that the child was in danger because her mother was there. And her mother had the child. And as the solicitor states, she'd always ride on Rita. And I'm not shooting at Rita. That's a different, not on my plate. But she relied on Rita. Only one person was responsible for the child that day. And it was Mr. King. Now, that would bring us to the conspiracy charge. Mr. King is also charged with conspiracy. I told you at the outset and got admonished for it. I don't know what the conspiracy to do with it. And it doesn't say. It doesn't say conspiracy to commit murder, conspiracy to cause great bodily injury to this guy, but a conspiracy. Okay. I'll assume, or I'll go with, that means he must have conspired, because the solicitor made a point of saying how they acted together, everything they did together. Well, he must have conspired to murder this child. Or he must have conspired, to cause great bodily injury to this child. I'll tell you what conspiracy means. His Honor's going to tell you shortly, but just so I don't get it wrong. Conspiracy is defined as the combination between two or more persons for the purpose of accomplishing a criminal or unlawful object, or an object neither criminal or unlawful by law. So basically it means conspiracy is defined as the combination between two or more persons for the purpose of accomplishing a criminal act. So he's alleging that Mr. King has conspired with someone to murder this child. Now, if you look up the word purpose, Google it, it'll tell you it means intention. The judge's purpose here today is to rule on matters of law and ensure that the defendants get a fair trial. The judge's intention here today is to rule on matters of law and ensure that the defendants get a fair trial. So, we can substitute that word and say a combination between two or more persons with the intention of accomplishing a criminal act. So, I told you at the outset this was a garbage indictment. It is. Certainly, even the state is not going to get up here and tell you that they have established evidence that shows Mr. King and Ms. Pangalangan somehow got together and decided, how are we going to murder this child? How are we going to hurt this child? How will we kill this child together? The law says they come together for the purpose or with the intention of accomplishing a crime. And it's absolutely devoid of any evidence that shows Mr. King ever intended to commit a crime. I'm almost done. do this, and then I'll sit down. Let me do this. Take you back to this tape and consider it this way. Blank slate. You watch this tape, and Mr. King walks out with his child in his arms. He places the child in the car. He steps back. Stay with me. He has a conversation with Rita. You need to go, etc. And then he turns around, he goes to the back of his house, he drives away. He's upset, he goes to his brother's house, he goes wherever he wants, he turns and he drives away. And then the events unfold exactly as they did here, without him being at his house. Is there any way, he's committed a crime? Is there any way he exhibited malevolence, ill will, or hatred? Is there any way whatsoever? And the only answer is no. Well, the only difference between the scenario I just described and what took place is that in this case, he was present when it took place. He didn't do anything different. He was just present. His honor was in integrity. That you cannot be guilty of a crime created by the presence of Christ. And Mr. King's undying regret already materialized. He was present when the crime was over, if y'all determined. But he did no more in reality than he did in the scenario I just described. Thank you.